Welcome to the first business and remote breakfast of 2021 put on by the Amesbury Chamber of Commerce. I'm excited that we've been able to partner in 2021 with Gould Insurance, and so Matt Sherrill, owner of Gould Insurance, has been fantastic with helping create this program where more members have access to the information that so many of our own members have to impart on people in the business community. So thank you, Matt. And so today we're joined again, as our first part of our business and breakfast for 2021, by Maureen Pomeroy. She's an Amesbury attorney, an employment professional guru. She is certified as a senior professional of human resources by the Human Resources Certification Institute, which is a private organization that is not regulated by the Commonwealth of Massachusetts or state of New Hampshire. But Maureen also has undergone training with the Massachusetts Commission Against Discrimination, which has allowed her to be a better asset to her clients with discrimination and harassment matters. So whether it's employment related or beyond, Maureen is somebody that we in the chamber and in the community more broadly have come to rely on for a lot of the information that helps us be better business owners and advocates. And so, Maureen, thank you for joining us today.
Oh, thank you for having me. I appreciate it. I look forward to bringing you information on this topic, and hopefully everybody leaves a little bit wiser on how to handle leave requests when they come up under this law. Can you share? Do I have the ability to share? Yes, I do. Wonderful. Okay, I do have a PowerPoint, which I will make available to those that have attended. And I'll play from start. Okay. So I understand that we are being recorded, and I just want to make sure everybody understands that this information is as good as today's date, January 20th, 2021. If you're watching this afterwards, I don't know how long it may be available. You just want to confirm that the information is still current on the date that you watch it. So basically, this law came up as a result of issues have been coming up more and more to provide job protected leave for employees. It started with the earned sick time. I want to say it was back in 2015, 2016, which you provide up to 40 hours of sick leave for employees for various reasons. This is paid family medical leave, and it's going to provide a certain type of leave, which we'll get into in a second. I just want to say thank you to our seminar sponsors, Amesbury Chamber of Commerce and Matt Sherrill of Gould Insurance Agency. Key aspects of the law, for if you're a geek and like to review statutes, the statute is General Law Chapter 175M, and you can review all of the different sections of it. But basically what this does is it's going to provide job protected leave for employees, which means that they're going to be able to take leave for certain reasons, and then their job is going to be protected. They cannot be discriminated against for taking this leave. There cannot be what's called adverse job actions or taken against them. They can't be fired. They can't be demoted. They have to return, and they receive basically the same status that they had when they went out on leave as when they come back. Weekly benefits can be up to $850 per week. This is all dependent on the average weekly wage over the course of a four prior quarters before the leave is taken. So it's just averaged out, and there's a formula. You can actually go on the mass.gov website under paid family medical leave, and there's a calculator on there if you're ever curious. It has you plug in numbers, and all you need is your payroll information for the prior quarters. And as I mentioned before, it's job protected leave. You cannot retaliate against an employee. What's retaliation? It's when you do anything to the employee that impacts the terms and conditions of employment. You demote them, change their position, change their hours. So it has some type of adverse impact, give them warnings. So there's going to be a lot of things that employers are going to need to prepare for this law when it comes to, say they have an employee that maybe not performing well, and they want to give warnings on performance related matters. There's certain things that you're going to have to do ahead of time and or think about if this employee has taken leave and within 6 months of returning from leave, this protection of no retaliation is still in place. We'll get into that a little bit more in a minute. So what is the law? This law allows employees up to 26 weeks per benefit year for certain qualifying conditions. It's not you get all 26 weeks except for one reason, but they can be used in a combination, a couple different reasons, up to the 26 weeks. So one is the employee's own serious health condition. If anyone has been subject to the Family Medical Leave Law, this is almost an identical definition under state law as it is under that federal law. That federal law, the Family Medical Leave Act, applies to employers of 50 employees or more. It provides up to 12 weeks, and in some cases up to 20 weeks of unpaid leave for serious health condition, birth, adoption of a child, qualifying reasons related to service member care or exigent circumstances. But in this case, what is a serious health condition is handled by a definition. Different issues can come up that could be a serious health condition, but normally transient medical conditions aren't considered serious health conditions. So for example, the flu, normally you get the flu, it goes away. You break a leg, it heals. Those are things that are considered transient conditions. However, if you have complications as a result of that, it may escalate into a serious health condition. So each own employee's scenario is going to have to be submitted to the paid family medical leave agency, and they're the one who's going to determine whether or not it qualifies as a serious health condition. So the next one is the birth, adoption, foster placement of a child. That is, you get up to 12 weeks within the first year of the birth or the placement. And that is, again, within the first year of the birth or the placement of a foster child. Next one is a qualifying exigency, or if it's for the care of a service member. You get up to 12 weeks for qualifying exigency. That's when, say, someone in the armed forces is called up to duty and a family member has to help that service member maybe take care of certain things before they go off on leave. That could be, you get up to 12 weeks for that reason. If in the event a service member is injured and you need to care for that service member, you can get up to 26 weeks of leave under this law. Effective July 1st, another portion of this law is going into effect. It's not in effect right now. So that is going to allow you up to 12 weeks of leave to care for a family member who suffers from a serious health condition. So who does the law apply to? This is where it gets really interesting, because it's not just Massachusetts employees, but yeah, a bulk of the people that are going to qualify this are Massachusetts employees who work for Massachusetts employers that get W-2 wages. Others that will qualify for this leave are contractors that reside in Massachusetts who provide services to a Massachusetts entity, and that entity maybe employs 50 or more contractors, 50% or more of the workforce, excuse me, for that Mass entity are contractors. So there's a reporting requirement for each of these. We'll get into that in a minute. Also, if you are self-employed. So if you're a self-employed individual who resides in Massachusetts, has a Massachusetts business, you may qualify for this type of leave. Now, in order to qualify, you have to meet not only the test that you're in a Massachusetts employee, contractor, or self-employed, but you also have to financial eligibility test. It looks at earnings that go back over 12 weeks, over the last 12 months, excuse me, last 4 quarters, and it will take the average weekly wage over that 4 quarters to determine the amount of that you would actually get in benefits. $850 a week is the cap. This is a state benefit plan. This has been funded by employee deductions from their wages for the last couple of years now. In some cases, employers are contributing. Depends on the size of the employer as to whether or not the employer contributes. But basically, the employer is going to report wages that the employee has earned over the last 4 quarters so that the mass agencies can determine how much the employee will qualify for. The agency is also going to determine whether or not the employee qualifies for leave if it's one of the reasons that we just went over. If it's a serious health condition for the employee, is it a birth, adoption, placement of a child, or is it exigent circumstances or care of a service member? And then after July 1st, it's whether or not the employee's going to care for somebody who has a, quote, serious health condition. Serious health condition is interesting. There are different tests for that. I just want you to realize that it can be under the care of a doctor for so long. it basically looks at sort of the different scenarios. And again, it's governed by the regulations. If you're used to FMLA, the FMLA definitions are very similar to the Massachusetts regulations on what qualifies as a serious health condition. And you can look at the regulations on the mass.gov website to determine, some of the different scenarios that may fall under that. But again, it's usually not when you break a leg or if you're suffering from the flu. It is a serious health condition. The payments are going to be made to the individual through the state agency. Again, it's a state benefit. It's going to be run like unemployment. The employee is going to be paid by the state agency while they're out on leave. Now, there's other details log, and you have to meet the financial criteria in order to obtain the benefits, which means you have to have been at least paid 30 times the weekly benefit amount over the past 12 months. So you basically have been paid wages during that time period. It doesn't have to be all from the same employer. It can be from different employers or different sources. You also have to contribute to the system for a certain amount of time before you become eligible, depending on who you are and how long you've contributed. It varies. Again, you have to qualify for the reason, and you have to have either a serious health condition, birth, adoption, placement of a child, and then the agency is going to ask for you information to establish that. So they're going to ask you for documentation, maybe information from the doctor. This is not stuff you're going to have to give to the employer. You're going to be giving it to the agency. The employer is just going to probably ask for details on, when are you going to be out, because the employee is going to need to give information about when they're going out. And normally they're supposed to give, we'll get into that in a second, at least 30 days notice if they know that the employee is going to have to be out. The employer needs to know ahead of time. It's supposed to be 30 days or as soon as practical. So it means if your employee is pregnant, they know when they're going to have the baby, they should be giving at least 30 days notice of when they're going to be taking the time. In other cases, when it's a serious health condition comes up unexpectedly, you may not get that notice until the day before or even after, but it's as soon as practical in that case. Again, serious health condition. So these are a couple of the definitions: inpatient care in a hospital, hospice, or residential medical facility, continuing treatment by healthcare providers. So those are certain standards. And again, the regulation goes into detail of what is continuing treatment. Again, it can range, but usually it's not anything that is transient in nature. It is something where you're under the care of a doctor. It's serious health, inpatient care at a hospital. And it can be a combination of those things as well. The benefit year, because I talked about the employee is eligible for up to 26 weeks of leave in a benefit year. The benefit year is calculated differently than FMLA. That's where it can get a little tricky for some employers who are subject to FMLA, which are, again, those employers of 50 or more. You still have to track everything under FMLA. FMLA has certain guidelines you have to follow about tracking time, certification, providing notice to the employee. All of that is still required. They're not required under the mass law, but you still have to follow it for the federal law. So what you should be doing is making sure your policies say they both run concurrent, following what you need to do with for FMLA about notification. I would leave, for the certification part, if you know your mass employee is going to certify under state law, you don't need to do anything. But if for some reason they don't qualify under state law, they may try to qualify under federal law. You may see that. So that's going to require you providing the certification form to the employee to go to the doctor, and the doctor's going to fill it out and give it back to you as the employer. And then you may have to make some determination on your own whether you think it qualifies, or seek legal help to see if it falls under the definition, at least under federal law. But again, federal law and mass law is very similar when it comes to the definitions of what is a serious health condition. So if it qualifies under mass law, it most likely qualifies under federal law. So you just want to make sure you get that tracking done, keep up your responsibilities under both laws. Again, like I said, for notice, they have to provide notice at least 30 days if they know they're going to be taking the leave, or as soon as practical in circumstances where they, comes up emergency, illness or something, and they don't have the ability to give you 30 days of leave. So notification, employers are supposed to notify employees about this law if they haven't already done so. Back in, I want to say 2019, the law said, okay, you should be handing out employees notice about this, that it's coming up in the next couple of years. And there's actually forms that you can get from the mass.gov website You don't have to recreate the wheel. You can use these forms. These forms should have been given to the employees back then. So if you haven't done it, do it now. Make sure that they know the law is in effect. But you're also supposed to be doing it at time of hire. So when you hire an employee, you should be giving this form. Or if it's a contractor and you fall under the contractor type status. So if you have 50% or more of your workforce are independent contractors, there's a notification for the contractors in your workforce. They should sign it and you should keep it in the personnel file. There's also a poster requirement. You have to post it in an area with all your other wage and hour posters, notifying the employees of the law. And there's also a requirement that you log into what's called Mass Tax Connect, which is the sort of like the platform for tax reporting and other things for the state of for the Commonwealth of Massachusetts. What you need to do is go into Mass Tax Connect and actually designate who's the person who's going to be the leave administrator for your organization. If you're a very small company, it may be you. If you are in a position where you're the HR person, it could be that person. It depends on what your company is going to want to do. So you're going to need to talk to, whoever is in charge of your organization to determine who they're going to designate as the leave administrator. But obviously, if it changes, you're going to have a responsibility to go in there and update. Because this is the person the mass agency is going to contact when an employee comes to them and says, I'm going to be taking leave. Oh, there you go. Leave administrator, just let you know this person's applied for leave, is now qualified to take leave, and it will begin on X. Hopefully the employee is said ahead of time that they're going to be applying for leave, so that you know that this is coming and you have as much notice as possible. So if you need these forms, again, you can get them from the mass.gov website. They have both the posters as well as the written notification requirements that the employees are supposed to be signing. Went backwards. All right. So one thing you need to understand is paid family medical leave is in addition to all other laws that may apply to your organization. I know we have a varying number. People need to understand that certain laws apply to organizations based on the size of the organization, which means how many employees you have. So if you have under 50 employees, as I was saying earlier, the paid family medical leave law Family Medical Leave Act, the federal law, does not apply to you. The paid family medical leave law applies to all Massachusetts employers of one or more employees, I should say most, because it doesn't apply to some governmental entities, but in general, it applies to most organizations that qualify for unemployment. Their employees qualify for unemployment. You're going to be an entity that this law applies to. So that means that all of the requirements for notification, for reporting to the agency, wages and hours worked or time worked, that's all going to have to be done by that agency, regardless of your size. But when you think about other laws that may come into effect, so say an employee applies for the paid family medical leave in Massachusetts, and you're under 50, and they, for some reason, they don't qualify. So somebody had a question about COVID. Does COVID qualify as a serious health condition? It may not. If it's only a transient, depending on how COVID impacts that individual, they may not qualify for family medical leave. If they just get flu-like symptoms, they recover completely and they're back to work within a few weeks. However, some people suffer from complications, or it just impacts them that much more, that they may be under the care of a health physician, inpatient care, so where it would apply to them. It's all going to be determined by the Massachusetts agency, and each circumstances are going to be different. So it's not a flat out, yes, it applies. It's more like it's going to depend on how COVID or any other similar type illness, which may be transient some, but actually impact them more seriously or maybe aggravates an underlying condition. That's going to make it, up to the agency to determine whether or not it qualifies. So say they don't qualify and they come back to you. So what are the leaves available in Massachusetts for an employee who has COVID? Well, first up, you have the earned sick time law that all Massachusetts employers are supposed to provide protected sick leave. Depending on whether or not you pay that sick leave depends on how many employees you have. 10 or less, you don't pay it. 11 or more, you pay it. And it's up to 40 hours of protected leave for an illness and to go to see the doctor. And there are a couple other qualifying reasons. does it raise to the level of a disability? And if it does, Massachusetts employers of 6 or more employees have to follow the state law. There's a federal law that's very similar. So does it rise to the level of a disability where you may have to grant unpaid to the employee? That's possible. So you always have to remember each one of these laws always works in connection with other laws. So if you have, you're not just dealing with the paid family medical leave. If for some reason they don't qualify, you need to look at other leave laws that may apply to your organization to make sure that the employee is being offered what's promised either under the law or if your policy. So this is the time to take a look at your policies. If you offer unpaid leave for a very generic reason, they may qualify for that leave. So, is it time to amend your leave to be more specific and targeted on when you're granting time off? Americans with Disabilities Act or the Disability Discrimination Law, in some cases, unpaid leave would be a reasonable accommodation in the event, again, does the illness rise to the level of a disability? Disability is very broadly defined under both state and federal laws. It's usually anything that impacts the activities of daily living, breathing, seeing, speaking, reading, listening. These are so you see how broad it is. But usually, again, it's not something that's necessarily transient. So you have to figure out, does the standard meet a disability under those laws to where they may be offered unpaid leave under those laws? And then, of course, if you have collective bargaining, that raises a whole other host of things because you have to always provide what's promised under collective bargaining or, again, as I said, your policies. Again, it's job protected leave. And what that means is when I said is you basically, the employee gets the same position that they had before they left on leave. It's the same status, same benefits. They should also have insurance should be continued through this time period. So you may have to work out with the employee how they pay their portion. If there's an employee portion to be paid, sometimes they pay it ahead of time. Sometimes the employer will just pay it and then try to get reimbursement on the back end when the employee returns. You can't take away any of those benefits from the employees. That would be considered a adverse job action. So say they get a seniority benefit, they go out and they come back. You can't deduct the time they took away from their seniority benefit. So again, that would be considered an adverse action. Employees have a private right of action against the employer if they believe that they have been discriminated against by the employer. As a result of they would claim retaliation. I came back from leave and I was given warnings. I was moved to a different shift, really impacts me in an adverse manner, where they fired me. So those are all types of claims that within 6 months of the returning from leave, that's the protected time period. So if employers take adverse actions during that time period, they may be subject to a claim by the employee. So again, you need to understand how to balance performance issues with an employee that's returning from leave. And I would get legal help with dealing with this because it's really tricky. There are some ways employers can protect themselves, and I'll explain that. The employers may opt for a private plan. If you're a large enough organization that offers short-term or long-term disability to your employees, you may want to talk to your insurance broker. You can opt out of the plan. The plan has to provide the same benefits as the state law. You can't offer less. But some employers have been exploring that. I just say, basically discuss it with your broker because they're going to be able to at least break down the pricing for you. How it impacts your the current benefits you provide. Is there overlap? So you definitely want to have the discussion to see if that's something you may want to try. Obviously, from a cost perspective, this is a state-run benefit plan that's paid mostly from employee payroll deductions and not from the employer. So again, I would look into that to see, even if you're currently offering, depending on the insurance, if there's overlap with what you're currently offering and what this Massachusetts law provides. You may want to consider just having an audit of your benefits. So one of the ways you can avoid the retaliation, or at least defend against a retaliation claim, is if you have existing policies that you're going to enforce for all employees. So this you have to have them in writing. So if this is the time, if you don't have a handbook, you might want to think about getting one. So if you have these things in writing and you're enforcing policies that have been written and are in existence prior to the person taking leave, employers are supposed to still continue to be able to enforce them. So if the employee returns from leave and you're having serious performance issues, as long as you're not targeting them and you're applying this policy in a consistent manner against as to all of your employees, this can be an affirmative defense against an employment for a retaliation claim under this law. So I think it's really important that not only are you updating your leave policies because of this law, but you're also looking at your performance policies, making sure that they're in writing, that the employee has a copy of it, that you've got a signed acknowledgement page, that they have a copy of the personnel manual. And, because this is, employers always want really great employees, and they want to be able to, give warnings if they need to for employee conduct that may be violative of the standards that the employer wants. Again, you have to understand right now how leave laws impact your organization. This new leave law is coming in addition to other leaves that are available under state and federal laws. So you just want to make sure your policies are up to date, that there is a policy that in there about the family medical leave law for Massachusetts employees. You also want to make sure you're always documenting employee performance. I can't stress this enough. I tell all of my clients, you have to write. If it's not in writing, it doesn't exist. It's that simple. Going up to court and having the employee on the stand saying one thing and the employer saying something else on the other stand, the jury gets to decide who they believe. And it's a lot stronger if you have, in addition to somebody testifying, something in writing that corroborates what the testimony is. So if you don't have that, it's going to be very difficult to defend, especially these retaliation claims. The onus is on the employer. Actually, the burden is on the employer to prove by clear and convincing evidence they didn't retaliate, which is an unusual shift in the burden. Usually it's the employee who has to prove their case. There's an automatic sort of, there's an inference going into it that if you've done anything adverse and taken any adverse action against the employee within 6 months of returning from leave, it's the employer who has the burden to show that they didn't discriminate or they didn't retaliate. And that the one way you do that, that's why I'm saying the written leave policies is how you prove that. So you want to be able to establish that by showing the written policy that we were enforcing our policy uniformly. This is what it is. It's in writing. The employee had notice of it and they violated it. Again, so that's one that shows you how that affirmative defense works and how I can defend against such a claim when one of my clients is up against this.
Can we jump in now for questions, or
Yep.
is that waiting for
This
later?
is-
Okay. So Maureen, on that, what if your employee, so you're trying to document it, do they have to sign something that goes into their file? And what if they refuse to sign it? Like if I don't know what that would be at this moment, but let's say, maybe we'll tie in this thing with the COVID thing. Okay, so we call it, and boy, the subjectivity of all this law is frustrating as hell, I must say. Because I'm trying to give advice to my clients. Now, I am not a CPA like Monique. I am an accountant, which just means that I do, helping them understand their numbers and things of that nature. I do have a CPA all CPAs I work with, so I'm not in that realm. So my people come, we do bookkeeping, accounting, business consulting, and they say to me, what's going on here? And this client just on Friday told me about this employee with COVID. Now he's back. So listening to you today, I'd say, one, it's transient, but is there anything that she should document? And I do want to say this. She flippantly said to me, because she's kind of a personal friend too, over the years, and said, oh, well, dude, you're not getting your bonus next year. You try and soak me for this. I'm like, whoa. You can't, first off, don't tell me that. And secondly, you can't say that. And I'm going to advise her, do not do that, because the bonuses come out next December, because, it's a lawsuit waiting to happen from what I'm understanding from you. But what if they refuse to sign something? Well, in this matter, wouldn't you put down something like they were out for COVID, he's back to work? What would you do?
Okay, so the documentation part of this law is you have to provide notice. I would be tracking the benefit year. So when the benefit year starts, and that's the week prior. I could say, so the employee says on a Monday, I'm going out on leave. It's been approved. It starts Monday. So their benefit year starts the Sunday before And then you have to count 365 days forward. That's their benefit year. So they're allowed up to, depending on what type of leave, they're allowed so many weeks, but they're allowed up to 26 weeks. So for purposes of tracking, because I know Brian asked this, I don't think you necessarily have to do it through payroll, but you want it to internally at least keep track of the time that an employee takes under this law. And the only reason is so you as the employer know, when are they going to hit that 26-week mark? So if they go out 12 weeks for the birth of a child, then say a serious health condition happens, they get another 12 weeks. So that's 24 of the 26 weeks. So they could actually have 3 reasons. So let's say they go out for birth or adoption of a child. They could go out for their own serious health issue, and they could take the full 26 weeks. They couldn't take 20 weeks and 12 weeks within that same year. So you have to, again, that's just so you know where it ends at the 26 weeks with, and then the benefit year is calculated from the Sunday before the day they take the leave, counting forward 30.
Okay, now have you heard anything in Massachusetts about COVID specific? This guy, again, just a worker, had said to her, I think there's something specific about COVID that I can get paid for without having to take it out of my sick time.
That's the, so that was the law. Here's the fun part. That was the federal law, Corona, I don't have it in front of me, but I know I'm going to mess up the name. The first Family Coronavirus Response Act, I believe. It was a federal law that was under the CARES Act. It expired December 31st, 2020. It's done technically, so that employers do not have to offer this paid leave for coronavirus related reasons if they don't want to. However, accountants and you and Monica like this one, there is still a payroll credit available. If employers want to voluntarily offer this paid leave, they can get payroll credits through March 31st, 2021. So
what's a payroll credit? What's that
against the payroll taxes that the employer would pay.
I see. Okay.
What about the Family Medical Leave Act? Didn't they allow that to pay COVID people who were out testing and had quarantining?
No, that was the federal law that I just talked about that they did pay up until the end of December 2020. They were paying people up to 2 weeks, up to 80 hours of paid leave for COVID-related reasons, whether it was testing, quarantining, all of those COVID-related reasons. That law is no longer in effect. However, an employer may voluntarily continue to allow that 2 weeks of leave, and they would get payroll credits for the withholding tax that the employer pays up through March 31st. But that law is no longer in effect. Anybody who wants to continue to offer it, it would be voluntary. Again, if you want to take advantage of payroll tax credits.
Thank you. One more question I had, and then that's it. I have actually a labor lawyer in Boston, and she's very concerned. She has one employee. She's the only client that I still do payroll for, and we do it manually. She's very concerned. We have not been taking out any money of this one employee to provide for I guess it would be the what's the one in Massachusetts called? It's the family
medical leave. Yeah, that was a mandatory payroll deduction. So you should be calling the agency to see what you owe so you can get that employee caught up.
Okay, so we were supposed to be taking out that portion. And who do I call about that? Because she doesn't use any payroll company. I told her to talk to her CPA, maybe for the details, and then we would do whatever we needed to do.
But you definitely want to get a hold of the agency. It's probably going to, and then it's going to involve the Mass Department of Revenue to. Oh,
the Mass DOR.
Well,
yeah, you know how hard they are to get a hold of right now.
Start with the agency first.
Yeah. Okay, great. And then they could help us with the calculation. I appreciate that so much. No, and thank you, Maureen, for talking today. Sure. It's very timely.
Next, I think, Brian, did you have another question?
Yeah, I did. You on the list was hospice. Is that for a family member, or do you have to hold their job?
Yes. So
if they're in hospice?
Effective July 1st.
That's for a family member.
Yes, a family member. Yes, an employee.
Not for them in hospice. That would kind of be.
Technically, if it qualifies as a serious health, it's the holding of the position. Understand it this way. If you want to put somebody temporarily in that role until you're definite that the person's not coming back, you can always do that. You just have to let the person know you're putting temporarily in the role. You're here temporarily. And because we have somebody out on leave, you don't go into much more detail than that because of privacy rights for the employees. You just want to keep it simple. Somebody's out on leave, we expect them back. If they, for some reason they don't come back and it works out, great. If it doesn't, you just have to understand this is a temporary fit. But
Document, back to documentation on employees. Will documentation that isn't signed by the employee, will that hold up?
So, oh yeah, and that was the second part of
As a paper
her question,
trail,
yes.
if it's a continual with dates, not wanting to further aggravate a situation?
So the way you handle employee documentation, you basically want to get, so it's a warning. Let's use a warning or even a personnel review. So you're doing a review and maybe it's not a great review. And the employee is like, I'm not buying this. I didn't do this. This is, nah, I'm not signing it. Well, okay. There should always be a line underneath where it says employee signature, employee refused to sign. And all you got to do is employee refused to sign, the date, because the key is whenever you put something in the personnel file, mass law says if it impacts terms and conditions of employment, so if it's anything adverse that may affect a raise, a bonus, or anything, the employee has to know it's going in there. So you just have to provide notice, and notice is giving them a copy of that warning or the bad review. Do they have to sign it or should they sign it? Signing it is a great acknowledgement that they received it. Otherwise, they're going to take the stand and go, I didn't get that. And it happens more than once. So if they refuse to sign it, then you just have to say, okay, refuse to sign, here you go. And you give them a copy of what you executed. Is it what's exactly going into their personnel file? They can always refuse to sign. They don't have to sign. I wouldn't be terminating somebody over refusing to sign. I would just say, and refuse to sign, here's the date, here's your copy, it's going into, and make sure it says it's going into the personnel file. That's how you handle it. And then you would take the stand and say, I had the interview with them. It was on this date. I gave them a copy. Look, and here it says they refused to sign it.
The paid family medical leave, how is it calculated? Is it, I called my payroll company and I said, look, we need to talk about this. And he said, oh, don't worry about it. It's based on this salary.
Yep. So you don't have to do anything.
They pay. Okay.
Yeah,
it's automatically deducted from both of us, right?
It should, yeah, the payroll company should have been deducting this amount.
They were.
Yeah.
They have.
So that means that as long as your employees have been paying into it for a certain amount of time, and it doesn't just have to be you, it can be prior employers too. They've paid into the system long enough. I believe it's 3 quarters. But if they paid into the system long enough, then they will be eligible to take the leave. If they what they can do is if they haven't only been, here's what's interesting. If they say they've only been with you a week, they potentially may still qualify for this leave because of their work from other employers. So that's, and terminated employees too.
I'm obligated to hold their job for 6 months.
You're obligated to give them a job that's the same type of position, same pay, same level, benefits. Right. So yeah, so it's similar to other laws like the disability discrimination law. You got to give them a pretty much a similar job. So say for whatever reason, you don't have that specific job, they have to be offered some job. So again, it's like when you,
do they have to be a full-time employee?
If they had full-time work going out, yeah. When
what
they come
determines
back,
a full-time employee? My people are paid commission. They make really good money, and they may work anywhere from 20 to 30 hours. Could be 19. They still would make a good salary. What determines a full-time employee, both for the FMLA and the PFMLA?
Paid. Do you have over 50 employees, Brian?
No.
So then the federal law doesn't apply to you. So what you're looking at is just the paid family medical leave.
Okay.
And they're not looking at full or part-time. They're looking at paid into the system. Right.
Okay.
So all you have to do is offer them the same opportunity to make what they were making before they took the leave. So they work sporadically and didn't work completely full-time, as long as they have the ability to work that time and you're not restricting them in any way from.
Right. How do they, if I can just, divert this just a little bit, digress a little, the FMLA, how do you track the hours that
FMLA,
I am
if you were
obligated?
If you were obligated to do it, that should be an internal tracking of the time, because there's certain qualifications you have to make, but it should be an internal calendar that's kept. That's not something you track necessarily with payroll.
Okay.
So your HR person should be keeping a calendar when people are taking leave like that is not sick leave, which would be, or sick or vacation times usually.
It's
tracked in
unpaid
payroll.
sick, unpaid, but what's the maximum they can earn? Up to
For-
2 weeks?
For what law?
Unpaid sick time, FMLA.
FMLA doesn't apply. FMLA, so we've got a bunch of different leaves here we're talking about. Paid family medical leave is the Massachusetts law, and they can take up to 26 weeks for various reasons.
I understand that, but on
Okay.
FMLA, if you don't mind.
FMLA doesn't apply to you if you don't have 50 or more employees.
I thought I had to track it and give them unpaid. They're protected.
That's a different type of, I'm talking about Disability Act, Americans with Disabilities Act, or the state disability laws. There are some unpaid. The time is going to depend. There's no set limit on those, on the disability discrimination or the disability accommodation. You'd have to, call me and we could talk about it depending on the scenario. I mean, it's not forever, but it can be for unpaid leave under the Disability Act. It could be an extended amount of time, and we would talk about how you deal with that. Each scenario is different.
Thank you.
No problem. Anybody else have any questions on
I
this?
did.
Yeah, go ahead, Kristen.
With regards to the pandemic, I know that you had talked about the 52 weeks prior to when they had, when they file a claim. Would being like an employer puts an employee on unemployment due to the pandemic in the last 52 weeks, is there anything that would, hinder that employee's ability to apply for any of these leaves? Like, is there I don't know how to ask it.
No, I think for the eligibility, the financial eligibility, because they're going to look back a full year.
Right.
So there may be enough time in there where they qualified or paid into the system. Unemployment may throw a glitch into that. So they just have to talk to the agency if they're coming up. If you are a sole proprietor, you have to have paid into the system. So if you're the owner of the business, it's good to know that you can buy into the system. You can pay into it through Mass Tax Connect. You sign up and you'd pay your projected earnings quarterly. And then you can qualify for this after you've been paying into it for a certain amount of time. Again, it depending on your status, it depends the amount of time that you have to pay into the system. But again, the mass.gov website has a lot of great information about this law. Is not a lot of heavy lifting for employers, but it is going in and checking your handbooks, making sure you've got this law in there, that you've changed any of your current leave laws. If you have a lot of squirrely general language about unpaid leave, you want to address that in there. You want to make sure everything runs concurrent. If you're subject to FMLA and PFMLA, paid family medical leave with state law, FMLA is a federal law. Again, only applies to employers of 50 or more employees for the federal law. This state law applies to most Massachusetts employers of 1 or more employees. So you just definitely want to make sure your policies are up in effect. And I'm also offering a seminar on February 3rd. I'm going to be talking about it for an hour and a half with an HR consultant. We're both presenting. So I'm doing the law. She's doing the HR portion of it. So how do you sort of implement it? Some things she's finding. She's also filed the claims for people. So it gives a lot more detail on some of the more details of the process. And that's on February 3rd. You're welcome to email me and I can send you the link for that.
Maureen, if you'd like, I can also blast out the email link.
Sure.
To
I think I have a.
Go.
It's So it's a small fee for the administrative costs that we're incurring on this, but happy to. It's going to go into a lot more detail than the time I have here. But I'm also happy to answer questions offline. So if you email me, I'll see what I can do for you. And making sure that everybody's got the questions. Just making sure if you have questions. Oh, that was you, Phil. All right, we're just making sure the chat, I got to everything. But
will you guys email out the presentation to us?
What is it?
Yep.
The presentation that we saw today, you said it was available to us.
Yes, since you attended, you will get a copy of the presentation. Again, it's not, I always say it's not legal advice. It'll say something on there about it. It's not legal advice. It's only good as the day it was given to you. And you want to always make sure that the laws get updated sporadically. Regulations can be updated even though the law is not updated. So the regulations interpret the law and can put more things, requirements out there that you may not know about. So I always want to make sure that you have the most up-to-date law. I have a newsletter, so if you want to sign up for that, it's on my, it's free. You can sign up on my website, and I try to get it out monthly, whatever it is. The next one's going to be about the law changes that went into effect January 1st for Massachusetts, New Hampshire, and I got one in there for Maine. So I am licensed to practice in Mass, New Hampshire. So
Maureen, I do have one question. So I just want to make sure I'm clear. As long as it's applied to the payroll deduction for the mass paid family leave, do we, as an employer, do we have to pay into anything else if our employee takes up to 12 weeks off, or is that everything is now through the state? They just have to file, and we just have to be on the Mass Tax Connect as a designated administrator, right?
Administrator. Yep. So what's going to happen is the employee is going to apply. Hopefully the employee has told you they're going to apply, but you're going to get notified by the Mass agency that this employee is applied, they have qualified, and they're going to be taking leave on this date. As long as you've done the payroll withholdings, if you're a small enough company, the employer doesn't pay for this. It's been all taken from employee wages. But as long as they've qualified, all you're going to have to do is just make sure that their insurance continues while they're out on leave. Make any arrangements with the employee on how you want to deal with their paying their portion of the insurance, whether it's before or after. You can always work out something. And then the employee should keep you, if you're going to require a return to work certification, that's something you probably want to put it into effect now, so that you get some type of clearance from the employee that they can return to full duty. Because here's what happens. So say they come off leave and it's for a serious health condition, and maybe they can't work all of the duties that they used to do. Guess what? That disability discrimination law that Brian and I were talking about, ADA and the mass discrimination laws, you have to, under the disability laws, you may need to give reasonable accommodation if whatever they're suffered from is a disability. So that's how when they come off a mass leave, they may not be at 100%, but there are other laws that would require you to provide reasonable accommodations if it rises to the level of a disability, and how that looks like. And there's this whole I'm going to get into that in the seminar, of doing the interactive process between the disability laws and somebody who comes back off of family medical leave. So it's like, again, don't get tunnel vision. One law is applying, all the laws continue to apply. So you always have to read into it. There's workers' comp, there's disability laws. If you're large enough, FMLA, all of those get read together. So it can get a little convoluted. That's why I say get help, because a 20-minute, 30-minute conversation with me can save you having to deal with the legal claim later down the line. It's a heck of a lot cheaper to get advice before the incident than after. Hopefully that answered the question.
And we'll make sure that we get your contact information out to everybody as well. And so
great. So I'll send you the presentation, Phil, and then they can forward it out. Yeah, and he'll give me the contact information there. And like I said, I'm happy to answer anything offline if you have any other questions.
Well, thank you, Maureen. And thank you to everyone for attending. And of course, to Matt Sherrill of Gould Insurance for allowing us to distribute this information out to the broader membership. One of the silver linings of what is otherwise an unfortunate reality of having to meet via Zoom. So thank you to everyone for joining.